seats. We're going to try to stay on time.
Good morning. So quickly, who am I? I am I'm a law professor. I'm from Minnesota, and I know there's a lot of Minnesota people here. Who's from Minnesota? See? Okay. There's more. I guess they're not here this morning. So I teach at a law school in St. Paul, Minnesota. But of course, in March, St. Paul actually looks more like this usually. And I've been there since 2012. Before that, I grew up in Pittsburgh. Then I went to Georgetown, where I got a PhD in philosophy and bioethics, and I went to law school at Georgetown, clerked on the U.S. Court of Appeals for the Seventh Circuit. I was a practicing lawyer in Los Angeles, and then I moved into academia, and I've taught at law schools in Memphis, in Philadelphia, and now St. Paul. So I'm a law professor, but I mostly speak and write directly to clinicians. So most of my publications are in medical journals or nursing journals, so the audience is not other lawyers or law professors, but clinicians. So I have a regular column in the ASCO Post, which is the American Society of Clinical Oncology, and I write about all range of end-of-life issues from a legal perspective. And I'm a co-author on this book. It's a 1,500-page legal reference treatise called The Right to Die, The Law of End-of-Life Decision-Making, and I have a blog called the Medical Futility Blog, which is coming up on 4 million page views. So here's what I want to talk about, right? We've heard ever since Wednesday here that there are more and more jurisdictions expanding end-of-life and liberty. And the main thing, the most visible thing that I've heard talked about is medical aid in dying as the most prominent of these options. And of course that's legal in 7 US jurisdictions, maybe soon 9, probably Hawaii very shortly. But that leaves it still illegal in 49 US jurisdictions. So, we need to look at other exit options to supplement or complement medical aid in dying. And similarly, we've heard a lot here, it's been raised a lot the last few days, the dementia challenge, right? And that is a challenge even in the 7 US states that already have legalized medical aid in dying. And the reason, in a nutshell, is because you cannot, in those states, satisfy 2 conditions at the same time, right? On the one hand, there's a terminal illness requirement, right? So these statutes say that you can get the prescription only if you have an incurable and irreversible condition that is going to lead to your death within 6 months. And then these statutes also require that you have capacity at the time that you make the request for the prescription, right? The request can only be made solely and directly by the individual, not through an advance directive. So those are 2 of the several eligibility requirements in all the End-of-Life Options Acts. And you cannot satisfy that with dementia, because at the time that you still have capacity, you're not terminally ill, and by the time that you're terminally ill, you don't have capacity anymore. So you can't satisfy both of those eligibility requirements at the same time. Now, there are, by the way, some the largest professional medical society in the United States, American College of Physicians, says this is completely arbitrary discrimination. If you're going to allow it for people with capacity, then you have to allow it through advance directives. The Supreme Court of Alaska said it actually violates equal protection, which is a constitutional limitation on laws. It would be unconstitutional to allow it to, for people with capacity, but not through an advance directive. Now that's irrelevant because Canada doesn't allow it for either. But the point is, if you allow it for one, you have to allow it for both. So we may, right? These are just 2 lawyers that bring sort of constitutional cases. Kevin Diaz at Compassionate Choices and Catherine Tucker at the End-of-Life Liberty Project, and they may, right, in the next few years, bring cases in the states that allow it for contemporaneous people with capacity to allow it through advance directive, but that's years away. We heard earlier in this conference that Canada has commissioned a report, which is going to come back later this year to Parliament, about whether or not they should extend their law to allow medical aid in dying through advance directives. But then we also heard Dr. Green say that's not going to happen, at least for the next 10 years. So for right now, the only countries where you can get medical aid in dying through an advanced directive, through an advanced request, are in the Benelux countries. So we really, right now, and probably not for quite some time, a decade or more, are going to have any type of advance made in the Americas. In other words, there's no help, or MAID doesn't help the dementia situation, even in the states where it's available. So again, so we need to look at other end-of-life exit options. So the one I want to talk to you about this morning is VSED. How many people are familiar with VSED? When I say VSED, okay, so most people. So it's an acronym, right? It means voluntarily stopping eating and drinking. So MAID gets massive attention, right? Because it's in the bills between 20 and 30 states right now. So it's being covered by the media when they follow the bills as they progress in all the state houses. In contrast, VSED is like Cinderella, right? It's like the neglected exit option at the end of life. It doesn't get anywhere near the attention that MAID does. So just to lay a foundation real quick before we get to the heart of this, there's really three definitional conditions to VSED. What we're talking about is somebody who is still physiologically able to take food and fluid by mouth. So we're not talking about people who are right in the end stages of death and they just can't. They can, but they don't want to. So it's a voluntary and deliberate decision to stop. And the reason you stop taking food and fluid by mouth is because you want to hasten your death by dehydration. And that will happen normally between 8 and 14 days. Some people, there's some outliers, but normally between 8 and 14 days. Unfortunately, VSED gets a really bad rap. Whenever you have a campaign to legalize medical aid in dying, part of the argument for that is usually something along the lines of, we gotta legalize medical aid in dying because otherwise our only choice is VSED. And wouldn't that be terrible if that was the only way to hasten your death? So VSED is sort of thrown under the bus in order to advance the cause for MAID. So it's sort of been maligned unfairly. In reality, the evidence about VSED tells a different story. The evidence shows that VSED is a peaceful and comfortable way to hasten one's death. And let me just give you a few points on that. So one is we have a lot of first-person narratives. I collected a bunch, and this is an issue called Narrative Inquiry in Bioethics. It's a Johns Hopkins University journal. So I collected a bunch of people who told their stories. There's an advocate called Phyllis Schachter in Bellingham, Washington, who's done TED Talks. She has a book and a bunch of other materials on her website talking about how her husband used VSED to hasten his death. And there's other books out there. This is an older book. I don't know if people know the book Gramps, which is a story about how somebody hastened their death by voluntarily stopping eating and drinking. So there are some first-person narratives where people will tell their personal story about a family member. But we also have medical journal studies of VSED. This is one in the New England Journal of Medicine. In this study, they went to 100 nurses who had cared for VSED patients. And the nurses, so these are the ones who spend most of the time with the patient, reported that most of their deaths were peaceful with little suffering. And they said the benefits are that because of the duration of the process, it allowed an opportunity for reflection, family interaction, and mourning. No, absolutely, it's not for everybody. There's a really, she used to have, Diane Rehm, really high profile NPR celebrity, wrote a book because she lived in Washington, D.C., where at the time it was not legal, and therefore her husband hastened his death by VSED, and she thought that was terrible, and she included that in her book. So some people are not big fans of VSED, and that's fair. But it is preferred by many people. So let me just go back to Oregon, right? Obviously in Oregon, MAID has been available for 20 years. And in Oregon, even when you have both options, right? So in Oregon, you have the option of VSED and you have the option of MAID. Even when you have both options available, almost twice as many people chose VSED. And just a final point of data on that, it's a good option. just in the past few weeks, this is an article that I worked on with Tim Quill and others in JAMA Internal Medicine, explaining the clinical, ethical, and legal aspects to VSED. Again, Tim is really the expert on this, and he's a palliative care physician, said this is a peaceful and comfortable way to die. And then Tim just in the past few days did a second piece in the Journal of the American Geriatric Society. So we have peer-reviewed medical literature, validating that this is a peaceful and comfortable way to die. And then finally, there are growing professional society endorsements of VSED. Last summer, the American Nurses Association put out a policy statement saying, yes, we support this. The International Association for Hospice and Palliative Care put out a position statement. And then most recently, the Austrian Palliative Society put out a position statement. So there's a lot of support, right, in the clinical world, but the problem, and I'm a law professor, so this is what I'm going to talk about, is that there are some legal concerns and uncertainty about VSED. Theoretically, you could do it all on your own, right? You just stop eating and drinking, right? Well, you don't really need a clinician in the same way that you need a clinician to write you a prescription for succinylbarbital. But it's really, really important because you want an expert to be there to palliate your symptoms. The problem with that is there's a good amount of uncertainty and reluctance. This is just one study from the Journal of Palliative Medicine. They asked 600 physicians, what do you think the risk is if you were involved with somebody using VSED to hasten their death? And they put it, and these are a number of other things that physicians might do, like stop dialysis and using barbiturates. But it's a pretty reasonably high risk. They put it as a 3.3 on a 5-point scale in terms of their perception of how risky it would be to be involved with somebody's VSED decision. So I use a traffic light to sort of break down the legal situation, right? Red means stop, like the traffic light is kind of for your clinician. Like, so red means you can't do it, stop, you can't do it. Green means you can do it. And yellow means, well, it's not really clear. Well, no US jurisdiction actually prohibits VSED, okay, so there's no red lights, so that's good. But clinicians, as you may know, right, are really, really risk averse, legally risk averse. So the absence of a red light isn't good enough. What they want is a green light, affirmative, something from a regulation or statute that says, yes, you may do this. They want express permission, but there is none. Okay, so there's no affirmative permission in the law to do VSED, and there's really no judicial precedent either. So we really don't, this is the situation, we don't have any red lights prohibiting it, we don't have any green lights affirmatively authorizing it, so we just kind of are in this gray area, which is maybe great for people like Rob and I, because that creates jobs for lawyers. If it was all super clear, you wouldn't need lawyers. But anyway, the reason we don't have any guidance is because, again, VSED is the Cinderella of exit options. I would note, only because Shanaz pointed this out to me yesterday afternoon, to go back to Canada for a minute, just in the past few weeks, there actually was a decision from the College of Physicians and Surgeons of British Columbia, which is the medical board, the medical regulator, which basically approved of VSED. This was in the context of using VSED to then qualify for MAID, but at least they recognize that VSED in of itself, in a physician's participation with VSED, is really not a problem. So physicians ask, because we have this sort of yellow light situation, is it allowed or is it not? They ask, is it legal, right? That's what they would ask me, like, is it legal, can I do it? Or is it illegal? And those are really, I think, often not the right way to frame it, because law doesn't really work like that, right? It's not like legal, illegal. Law is really more about risk assessment. And so what we do as lawyers is we estimate how risky it would be, but it's hard to say it's absolutely risk-free or it's absolutely definitely going to land you in jail. So what I want to do is take two case types with VSED. And the first case type would be somebody who wants to use VSED now, like the patient right now, and she still has capacity, and she wants to use VSED to hasten her death. And then the second case type that I want to look at is somebody who wants to write an advance directive today to have VSED later when they lack capacity. Okay, so those are the two basically fundamentally different types of cases. So the first one is easier, VSED now by a patient who has capacity. So this is extremely low. So when the physician asks me, is it legal or illegal, what I say is, there's an extremely low risk of any type of sanction, whether criminal, civil, disciplinary, right? Extremely low. Why? Well, because people have a right to refuse medical measures, right? That's been well established for 4 decades, right? This right to refuse medical treatment. Now, normally when people think of the right to refuse medical treatment, this is the sort of stuff that they put within the scope of that right? Ventilators, dialysis, CPR, antibiotics, feeding tubes. Absolutely, people have the right to refuse those things. So the question is, well, is VSED inside or outside the scope of what is medical treatment that you're allowed to refuse? Well, unfortunately, it's a little bit unclear, again, because we haven't had hardly any cases on this. But VSED's not alone, because there's a lot of other stuff that we're working on, like so for ICD, implantable cardiac devices, pacemakers, and so forth. People are asking the same questions. Is that something we're allowed to turn off? Is that something you're allowed to refuse? So VSED's not unique in the sense of, is it inside or outside the scope of the right to refuse medical treatment? I think that VSED is most probably inside the scope. Why? Well, first of all, it's not do-it-yourself. It is medical treatment because it is part of a broader treatment plan. It is supervised by licensed healthcare professionals. There's actually a group at Harvard called the Community Ethics Committee. They actually don't call it VSED, they call it PAVSED, because in the extra 2 words in the acronym, palliated and assisted voluntary stopping eating and drinking. And the reason they add those extra letters to the acronym is to highlight the medical role in palliating the symptoms and highlighting the role of the direct care staff in providing assistance. Again, it's medical treatment. Why? It's recognized by the healthcare profession as medical treatment, right? I told you there's more position statements coming out from medical societies. There's more clinical practice guidelines. These are clinical practice guidelines from the Dutch Medical Society and the Medical College of Quebec. The Medical Board of Quebec said they're going to come out with guidance for physicians as well. So, in a recap, my argument is that oral nutrition and hydration is treatment, and therefore it falls within the scope of your right to refuse medical treatment because it is medical treatment. However, there's a good counter-argument to that, which is we really, and this is the Terry Schiavo, right, we really barely established that artificial nutrition and hydration is medical treatment. And to the extent that we did that, the argument for saying that feeding tubes and an artificial nutrition and hydration is medical treatment is by saying because it's not administered in a typically human way, right? And we're using tubes and things like that. Well, if that's the way that we justify artificial nutrition and hydration as being medical treatment, that sort of implies that oral nutrition and hydration is not medical treatment because it is administered in a typically human way, right? With a glass or with a spoon. So, again, my argument is not 100% positive. It may be that oral nutrition and hydration is not medical treatment, and therefore it falls outside the scope of your right to refuse medical treatment. But that's okay because I have other arguments. And this is powerful, I think, and most lawyers are on board with this. It doesn't matter if food and fluid is medical treatment or not, because you have the right to refuse any intervention. So we don't need to quibble about, is artificial, is oral, is hand feeding, is that medical treatment or is it not medical treatment? Who cares? People can't do stuff to you if you don't want them to do it to you, right? Unwanted contact, even if it's clinically beneficial, you can refuse, right? And if somebody foists that upon you, that's a battery, right? It's both a crime and a tort at the same time, right? We have this real famous case in Minnesota from 100 years ago where the patient consented to a procedure on her left ear, but the surgeon decided that he was going to operate on the right ear. That was the better way to approach it. That surgeon was successfully sued for battery because what he did was outside the scope of the patient's consent. Even though he was right, and it really was the other ear that was the problem, the point is you need to get the patient's consent. If you don't have the patient's consent to do something, you can't do it. Right? We have a lot of cases where there's unwanted cesarean sections. Force feeding is which is what this would be if you refused it, would be a battery. Our former Chief Justice Rehnquist made this observation in the Supreme Court. Bodily integrity is violated as much by sticking a spoon in your mouth as by sticking a needle in your arm. So, generally, there's a legal consensus that you have a right to contemporaneous VSED. Now, there are two other concerns. One is that VSED might be assisted suicide, and therefore the clinician or the family might be guilty of participating in assisting with suicide, which is a crime in every state. But it's probably not assisted suicide. It probably doesn't constitute the crime of assisted suicide. One reason is because of a very well-established active-passive distinction. Assisted suicide statutes target active conduct, right? So, shooting somebody with a gun or giving them some kind of drugs. So normally when people are convicted of assisting a suicide, normally what they've done is provided the physical means by which the other person commits the suicide. VSED doesn't have that at all, right? It's completely passive conduct. You're just not doing something. You're not doing anything. And also, almost every assisted suicide statute in the country has an exemption, which is if all you're doing is prescribing and administering or something for the purpose of diminishing pain or comfort, then that doesn't constitute assisted suicide. Well, that is the only role of the physician with VSED, is to palliate the symptoms while the patient dehydrates. So everything that the clinician does with VSED is expressly exempted in the statute. And by the way, there are many physicians who, like Tim Quill and others, who have reported they've helped many patients with VSED. There's never been a single criminal or disciplinary sanction imposed anywhere in the United States. And then finally, people are concerned that VSED might constitute abuse or neglect. You're allowing somebody to dehydrate. So the risk is that there are regs, a ton of regs that regulate nursing homes. And many of them say stuff like this, which is you have to ensure that every resident has sufficient fluid intake to maintain proper hydration health. So they're afraid that the inspectors, the surveyors, are going to say you're violating these nursing home regulations, and we're going to fine you or shut you down and kick you out of participation with Medicare or something like that. And in fact, absolutely, nursing homes get in trouble for this all the time. But when we're talking about VSED, things are totally different because the patient wanted to dehydrate. The reason people get in trouble is because you're allowing people to suffer who didn't want that. If that's what they wanted, you have to follow that. And all the Medicare regulations for nursing homes are really clear that these rights are there for the patient's protection, and if the patient wants to waive them, she can, and you have to honor the waiver. In other words, over-treatment is just as risky as under-treatment. So the risk is really, really low. It's not absolutely zero. You can never say as a lawyer the risk is absolutely zero. And so clinicians, there's a shadow, and they're more afraid of the shadow, than the actual risk. So they really do want a safe harbor, and of course, like I said, we don't have that. So that's advanced. That's VSED for people with capacity right now. What about advanced directive for VSED later, right? Why would you do that? Well, if you're going to do VSED today, right, when you still have capacity, that's because you judge right now the burdens of my life outweigh the benefits of my life. When you do VSED through an advanced directive, you're projecting that that your future burdens are going to outweigh your future benefits of life. So what are we talking about? Well, basically we're saying we're going to complete in advance, everybody in this room has capacity, we're going to complete in advance directive today, okay? And we're going to direct VSED in the future, right? We're going to tell our caregivers, whether it's family or professional caregivers at a facility, to not hand feed us, and we'll specify when that will be, when we reach a point that we find intolerable. And that's going to vary from person to person. And of course, you will lack capacity at that future point in time. So that's what I mean by advance VSED. Is that a viable option, right? Can you leave VSED instructions in an advance directive? Okay, well first, this is the dramatic part. Right? So if you know the when Henry IV Part 1, this is a little, like there's this great line where Glendower says, I can call spirits from the vast deep. right? And the response from Hotspur is what? Why, so can I, or so can any man. But will they come when you call them? Well, the point is, of course, is you can write anything that you want in advance directive. Anything that you want. The question is, will it be honored? And again, let me use the traffic light metaphor, right? Prohibited, unsure, or permitted, right? Well, there's no green lights. There's no specific permission for VSED. There are, in fact, red lights. There are absolute red lights. This came up yesterday in an open Q&A upstairs. Sometimes advanced VSED is absolutely prohibited in the United States. So just a couple examples, and there are several. In Wisconsin, absolutely says that a healthcare agent may not consent to the withholding or withdrawal of orally ingested nutrition hydration. So your agent there's a power that your agent, that the Wisconsin legislature has taken away from your agent that they might otherwise have had. New York also specifically defines oral nutrition hydration as not healthcare. And your agent has only the ability to make healthcare decisions on your behalf. This is not healthcare, this is not a decision they can make for you. So everybody has a really broad scope of autonomy, but when we're talking about prospect of autonomy, your ability to make instructions through an advanced directive or through a durable power attorney for healthcare, that's narrower, that's a smaller range of power. So we don't have any green lights, we have some red lights when it comes to advanced VSED. Most of this country is a yellow light, just unclear. Is an advance request for VSED enforceable? What I want to do is just give you two quick cases and then give you some practical takeaway tips. Okay, and some people may be familiar with these cases. The first case is from British Columbia, and the patient in this case was Margot Bentley. Margot Bentley had been a dementia nurse, okay? She had seen a lot, exactly what it is that she herself decided she wanted to avoid. She knew she did not want to live in a state of advanced dementia. So she completed, this is her advanced directive, she completed an advanced directive which purported and intended to avoid living in advanced dementia. And the most relevant parts of her advanced directive would be, I direct that I be allowed to die, not be kept alive by artificial heroic measures, and I don't know nourishment or liquids, okay? So her family tried to enforce this. She was at a facility, tried to get the facility to honor her advanced directive. The facility refused to honor the advanced directive. This is Margot Bentley, stage 7 Alzheimer's, and continued to hand feed her. And this is her being hand fed. So the family took this to the courts in Vancouver. Unfortunately, the family lost, and they also lost on appeal. Why? Well, the key, there's a lot of stuff going on in this case, but the simple takeaway part is this. This is the relevant language in the advanced directive. It says no nourishment or liquids. Well, and the court had a point here, because when you look at if we looked at 100 advanced directives or 1,000 advanced directives, what people for a long time have meant by that is this. This is what they meant. And therefore, the court determined that's probably what she meant too. Right? We don't have any evidence. We didn't have enough evidence otherwise. So the quick take-home lesson, or there's a lot of take-home lessons we can pull from Bentley, but I think the most important one is, if you mean hand feeding and you want to avoid hand feeding, say hand feeding, right? If you want to avoid oral nutrition hydration, say by mouth, oral, right? Use all of the adjectives and words that you can to make it really, really clear what it is that you're trying to avoid. Because the main problem in her case is it wasn't clear that this is this is the thing she was refusing. And then the second case is really, really similar. It's from Oregon, and the patient in this case was Nora Harris. Nora Harris also had an advanced directive. Arguably hers was even worse than Bentley's, because she had moved from California. She had basically a template. It wasn't a hand drafted like Margot's, a template California advanced directive that she brought with her when she moved to Oregon. And it, of course, like most advanced directives, doesn't address hand feeding or oral nutrition and hydration. And again, she lost, when her husband brought this to court to try to get the facility to honor Nora's wishes, he, like Margot Bentley's family, lost. And the main reason he lost is, again, not clear that this is what she wanted. So again, take home, if you want to avoid hand feeding, say you want to avoid hand feeding. So would better more clearly drafted advance directives have helped Margot Bentley or Nora Harris? Well, I don't know. But what's the point? If you don't try, well, you never know. I mean, it would have increased their chances of getting it honored by the facility and honored by the courts. It is really complicated. So here's just to make it real simple, here's a couple practical tips. VSED, as of right now, is kind of weird. And basically, here's a rule with advanced directives in getting clinicians to honor any wish, which is the weirder the thing that you're asking for, the better the evidence is that your agent is going to need that this is what you really wanted, right? If you come in and say, oh, don't give her any pain meds, that's freakishly weird, and maybe you can get that honored, but you're going to need some really, really strong evidence that she was a follower of some kind of religion that would make the pain meds, violate her deeply held tenets, right? So the weirder the thing that you're asking for, the more evidence the agent, the surrogate, is going to need to prove to the clinicians that this is really, truly what she wanted. And as of right now, VSED is still kind of like the black swan. So you have to be really specific on the when. When do you want the VSED to be implemented? And you have to be very specific on the what. What do you mean by VSED? Okay, so there are some tools out there to answer these questions about being specific on the when and being specific on the what. Okay, one is the tools that have been developed by Stan. People know Stan Terman? Some people. So Stan Terman is a psychiatrist, and this is his absolute passion and has been for probably a decade or two, which is helping people avoid living in a state of advanced dementia that they would not want to live in. And he has a ton of tools and a ton of videos, right? So it's actually almost too much. But the one thing I wanted to highlight was this one tool that he has. It's a deck of cards. They're called My Way cards. And it's a tool. It's a planning tool that would help facilitate a discussion between somebody who has advancing dementia and their family. The cards look like this. It would have different situations of dementia. So this one just says, and it has a little cartoons for each one. So loss of personal identity. I do not seem to know it is me when I look in the mirror. I can't tell others anything about me. When I see people in my close family or see my best friends, I don't know who they are. I don't use the bathrooms. I let my clothes get wet and dirty. Others must change my diapers. So these are all situations, and the idea is you would sort these cards into piles, right? And these would be like if I meet these conditions, those are conditions that either all by themselves or at least these 5 together, if they're all met, that's when I want the VSED. It helps you define the when. It helps you define the situation, the trigger point that you would want VSED. And there's like 100 cards. Okay, so that's one tool to help define the when.
What was the author of that?
Terman, T-E-R-M-A-N.
Is it available on the internet?
He is, we heard from Dr. Z-Dog. Terman's not quite Z-Dog, but he's up there in terms of the amount of YouTube and other stuff that he has out there.
What's the name of the cards?
My Way cards, right? Because they help you do it my way, like the Sinatra. I think that's where he got it. The Frank Sinatra song. Okay, so a couple other tools, right? End of Life Choices New York. I don't think this is up on their website yet, but it's about to be. So it's called Advanced Directive for Receiving Oral Food and Fluids in Dementia. And the idea here is all advanced directives that are out there, 5 wishes and the state forms and the Catholic forms and the Jewish forms, right? Nobody is addressing dementia and nobody's addressing VSED. So this is a unique form. And the idea of a form is it gives you prompts in language, right? So it will prompt you to clearly specify what it is that you want, both in terms of when and in terms of what. And then finally, since they're here, End of Life Washington.
Yeah.
So also recently put up on their website, theirs is already up and live, my instructions for oral feeding and drinking. So there are more and more tools being developed for advanced VSED. Unfortunately, Apart from those examples, there aren't a lot of other tools, right? I'll note that CNC, Compassionate Choices, has a little booklet. It's not nearly as good as any of the other three, as End of Life Washington, End of Life New York, or Term and stuff. So some of the big players like CNC just aren't getting into VSED. They really aren't providing tools, planning tools, even educational tools. So it's sort of been neglected, and that's sort of my take-home point. VSED is an important end-of-life option. It's important because MAID, as I started with, leaves dementia people completely out, and of course most people don't even have MAID in most jurisdictions. So VSED is really important as a complement and supplement to MAID, but we need a lot more education and a lot more planning tools to be developed by FEN, by the other organizations. Thank you.